How Supreme Court judges are appointed. A record of 9 judges have been taken oath at the one go, taking the Supreme Court strength to 33, of whom 4 are women. How has the process of appointment in the higher judiciary evolved amid a tussle with the executive? 9 judges of the Supreme Court took oath on Tuesday, the biggest ever number at the one go. A third of the new judges are women, another first. Even though the 33 strong bench still has only 4 women, how are Supreme Court judges appointed? Who appoints the Supreme Court judges? Article 124(2) and 217 of the Constitution governs the appointment of judges to the Supreme Court and High Court respectively. Under both provisions, the President has the power to make the appointments after consultation with such of the judges of the Supreme Court and of the High Courts in the state as the President may deem necessary. Over the years, the word consultation has been at the center of debate of executive powers to appoint judges. In practice, the executive held this power since independence, and a convention of seniority was evolved for appointing the Chief Justice of India. This changed, however, in the 80s in a series of Supreme Court cases in which the judiciary essentially impounded the power of appointment to itself. What were these cases? The tussle between the executive and the judiciary over judges' appointment began following as the Indira Gandhi-led government's move in 1973 to supersede 3 senior judges and appoint Justice A.N. Ray as the CGI. In three cases, which came to be known as the Judges' Case in 1981, 1993, and 1998, the Supreme Court evolved the collegium system for appointing judges. A group of senior Supreme Court judges headed by the Chief Justice of India would make recommendation to the President on who should be appointed. These rulings not only shrank the executive say in proposing a candidate for judgeship, but also took away the executive's veto power. In the first judge case, S.P. Gupta versus Union of India 1981, the Supreme Court ruled that the President does not require the concurrence of the Chief Justice of India in appointment of judge. The ruling affirmed that the preeminence of the executive in making an appointment, but has overturned 12 years later in the second judge case. The Supreme Court advocate on record Association versus Union of India, a 9-judge constitution bench, evolved the collegium system for appointment and transfer of judges in the higher judiciary. The court underlined that the deviation of the text of the Constitution was to guard the independence of the judiciary from the executive and protect its integrity. In 1998, President K.R. Narayan issued a presidential reference to the Supreme Court over the meaning of the term consultation, whether it required consultation with a number of judges in forming the Chief Justice of India's opinion, or whether the CGI's sole opinion could by itself constitute a consultation. The ruling on this established a quorum and majority vote in the collegium to make recommendation to the President. In 2014, the NDA government attempted to claw back control on judicial appointment by establishing the National Judicial Appointment Commission, though constitutional amendment. Although the law which gave the executive a greater foot in the door in appointment had support across political parties, the Supreme Court struck it down as unconstitutional. How many judges does the Supreme Court have? How is the number decided? Currently, the Supreme Court has 34 judges including the CGI. In 1950, when it was established, it has 8 judges including the CGI. Parliament, which has the power to increase the number of judges, has gradually done so by amending the Supreme Court Judges Act number 8 in 1950 to 11 in 1956, 14 in 1960, 18 in 1978, 26 in 1986, 31 in 2009, and 34 in 2019. Even with Tuesday's record 9 appointment, the court continues to have 1 vacancy and 8 more judges are due to retire next year. How did this backlog accumulate? In 2019, the Supreme Court was functioning at its full strength of 34 when its Chief Justice of India S.A. Bobble took over. He inherited just 1 vacancy, that of his predecessor Ranjan Gogoi. However, the collegium headed by CJI Bobde could not reach a consensus in recommending names, leading to an impasse that led to accumulation of vacancies, of which now only 1 remains. The High Court judge on average have over a 30% vacancy. The age of retirement is 65 years for Supreme Court judges and 62 for High Court judges. Unlike in any say the United States where Supreme Court judges serve for life. This means that in India, the process of appointing judges is a continuous one, and the collegium system in a multi-step process with little accountability on even the timeline that the judiciary has set for itself. For High Court appointments, the process is initiated by the High Court Collegium and the file with then moves to the state government, the central government, and then to the Supreme Court Collegium after the allegiance reports are gathered on the candidates recommended. This process often takes a year. Once the Supreme Court Collegium clears the names, a delay also happens at the government level for final approval and appointment. If the government wants the Collegium to reconsider a recommendation, the file is sent back and the Collegium can reiterate or withdraw its decision. Has the number of women judges always been low? Lack of representation in terms of caste and gender has been an issue in the higher judiciary. Before Tuesday's appointment, Justice Indira Banerjee was the only woman judge in the Supreme Court. Justice B. Nagarthana is in line to become India's first woman Chief Justice of India 80 years after independence. In 1989, Justice Fatima Bibi became the first judge to be appointed to the Supreme Court. Since then, however, the Supreme Court has only 11 women judges, including 3 women appointed recently. A 2018 study by the Vidhi Center for Legacy Policy noted that while representation of the women in the lower judiciary is higher at 27%, they hit a glass ceiling in higher appointments as district judges and subsequently at the High Court level. Thank you.